welcome to Legally Speaking with me, Tarun Nangia. Today we're going to discuss an issue that concerns the whole business community in India. It is about the Lookout Circular and its impact on the business community at large. What needs to be done? Where have we come so far? What have been the important judicial pronouncements on this issue? So on and so forth. I have with me a panel that regularly goes to court on these issues. I have with me Advocate Rhythm Agarwal. She practices before different forums in the financial crime side, including a lot of LOC matters. Good to see you, Rhythm, and looking forward to some interesting insights. I also have with me Advocate Aditya Kumar. He is an advocate at the Supreme Court of India, and he's partnered with NKR Law Offices that has a financial crimes practice area where he also advises clients on these issues. Good to see you, Aditya. Looking for some interesting insights. At the outset, we'll first start with our round of introduction comments where people will speak, the panelists will speak from inception on the Lookout Circular issue and make a few initial comments on where have we come so far before we move into the specifics and issues affecting the business community. May I request Advocate Rhythm Agarwal, your introductory comment, please, and then we go to Aditya. Rhythm, over to you.
Thank you so much for having me at the show, Tarun. So let me start with what is an LOC and why it is. So basically, an LOC is a coercive measure to make a person surrender to the court of law or to an investigating agency. So an LOC is issued against a person if A, he's evading arrest, B, that he's not being present in court, C, that he's fleeing away from justice, and so on and so forth. Now, why the concept of LOC has taken so much traction is something to be discussed. So a lot of people say that LOC is unbridled misuse of power. Now, why we say that is because the principle of natural justice is not followed, and I am not given any chance to put my defense forth. It's just an LOC is just issued in a mechanical manner without any application of mine. So, for example, the principle of natural justice, audi alteram partem, that talks about my right to be heard, is not given to me. I'm not given a chance to show cause what that an LOC should be issued against me or should not be issued against me. What is my defense, and why am I made to suffer? So a person gets to know about an LOC issued against him right when he reaches the airport, not before that. So I am at the immigration, I reach the airport, I get to know an LOC is issued against me. Now one has to understand that why will a person travel apart from leisure purposes? A, he might be traveling for an important business meeting, B, for a medical emergency, C, maybe to get admission of a child to a foreign university, or D, God forbid, for attending a demise of a loved one. The emergencies are not going to knock on my door asking me or taking the permission of the court, right? They just arise any moment. And at that moment, I am stranded at the airport where I have to go back, deboard my luggage. I'm not refunded my flight ticket. I go out in a haste. I have to go look for a lawyer. And then you know how the litigation is in India, right? The time it takes. So then I go to the lawyer. I tell him my case. He's going to draft. The filing is going to take time. On the first day, the notice is going to be issued. Then a reply will be filed, which might not be filed because to delay the proceedings, and then hence so on and so forth. If you're lucky, when you get a permission to travel abroad or your LOC is quashed and you're in the High Court, then you have to go to the registrar again, give your passport, give your documents, etc., and then you're permitted to travel. And this vicious cycle repeats if you have to travel another time. Now, if I talk about the law on LOC, so the law on LOC was initiated by an office memorandum in 1979, but it came into traction in 2010 by the landmark judgment of Sumer Singh Salkhan that talks about when an LOC can be issued against, who it can be issued, what is the procedure to issue an LOC, and so on and so forth. Now, the judgment talks about that an LOC can be issued against a person, A, if there's a cognizable offense, B, he's trying to evade arrest, C, that he might flee away from justice, and D, that there are NBWs issued against him and still he's not appearing before the court of law. Now, in today's day and age, when technology has moved so fast, everything is available online. and I just have to join an investigation. A person might do that through VC. What is the reason to issue an LOC against a person? You take my Google location and you know where am I, where is the chance to flee away from justice in this matter? It is so unconstitutional and arbitrary in every sense possible, right? And the courts at the time when they're burdened with personal liberty matters, they have to deal with LOC matters. Now, after 2010, this judgment of Sumer Singh, in 2018, the office memorandum was amended to include banks and financial institutions. Where after the popular case where a liquor baron fled away from the country. Now, this particular circular is challenged in the High Court for its unconstitutional nature, because my right to travel is my fundamental right, because it curtails my personal liberty. And it has been held in catena of judgment like Satwant Singh Sahni, Menka Gandhi, where the Supreme Court has reiterated that you cannot stop me. And for example, if I'm going for a business meeting, then it affects my fundamental right to practice business and profession as well. And another aspect that's concerning is there is no clarity of forum with respect to LOC matters. If a bank issues an LOC against me, I go to the High Court. But if a CBI or ED investigation agency issues an LOC against me and a complaint is filed for the same, I go to the trial court. For the same cause of action, I have to go and knock doors of multiple forums just to get a permission to travel abroad or get my LOC withdrawn. This is at the time when we see that how many cases are pending in courts and how stagnant the litigation is. Should the court be dealing with these matters or be dealing with bail matters and personal liberty matters where people are actually arrested?
Point well taken, Rhythm, and well explained. I'll now take this point to Advocate Aditya Kumar from NKR Law Offices. Aditya, you've heard out Rhythm. We want to know your introductory comments on this issue, and also from the inception, and a few initial comments before we dive into the second and the third question.
Sure. Thanks. Thank you, Tarun, for the invite, and thank you, Rhythm, for that introduction into the subject. I think it was fairly detailed, and what I'm going to try to do is also talk about some of the things that Rhythm touched on, but maybe elaborate on some of the things that I find particularly interesting. So like Rhythm mentioned, the right to movement, especially the right to move abroad, was clarified by the Supreme Court of India in Maneka Gandhi. Thereafter, what they actually said was that there needs to be a procedure prescribed by law. Now, your legal procedure is obviously under specific statutes. It includes the Passports Act, for example, or the Customs Act. And that's an example with respect to traveling abroad. But what really happened was that the government needed a more generic measure to prevent people from leaving the country and also ensure that certain types of people are not entering the country. That was the birth really of lookout circulars. And like Rhythm said, it really started in 1979 through an OM. And over time that really developed, and different categories of items were added in terms of what kind of people are the lookout circulars seeking to cover. So originally, like Rhythm said, it's people who are seeking to evade arrest, who are proclaimed offenders. That was the original thought, eventually modified and included elements like terrorism. So if you were a terrorist, lookout circulars were issued. Not only, let's be clear about two things. One is to track movement, but more pertinently and typically in the types of cases that go to courts are where you are prohibited from either leaving the country or entering the country. So one important aspect to also understand that lookout circulars include both tracking of movement and prohibition of exit or entry into the country. Now, beyond terrorism, it also subsequently added elements like affecting the economic interest of India. That becomes relevant now because the circular as it stands today, as Rhythm rightly touched on, in 2018 was modified to, just to take a step back, there were certain categories of people who could only issue these instructions. So the lookout circular is essentially issued by an authorized governmental body. These authorized bodies are detailed in your circulars, and they include a variety of bodies. So it includes, like, for example, the DRI, right? Or the SFRO, most recently in 2017 was included. So there's the CBI, there are certain identified bodies who have the right to issue these kind of lookout circulars, which is ultimately implemented by the Ministry of Home Affairs through the Bureau of Immigration. Now, that's the whole mechanism of how it works. In 2018, though, interestingly, what happened was that the government included a particular category of people that it had not included earlier. And that was CEOs, MDs, and chairpersons of public sector banks. This is really where I think, the recent explosion in lookout circulars and unnecessary lookout circulars, if I may not be too harsh, unnecessary lookout circulars have started. The reason is that now what you have is a situation where the heads of private banks are issuing or asking lookout circulars to be issued with respect to particular individuals. Now, in 2019, the reason they included these categories of people was to ensure that certain willful defaulters or proclaimed offenders weren't actually leaving the country. That was the intent. But unfortunately, which is often the case, the language in the actual circular, because we haven't seen the actual OM because I believe it's unpublished, but there was a press release in 2019, and that press release was vaguer than it possibly intended to be because it said things like people including willful defaulters. So that situation led to a number of cases coming up, which we can maybe discuss in the next part, Tarun, where certain categories of people, which frankly who have no right to be involved or embroiled in a long litigation, have unfortunately been embroiled in these litigations. So just to take one example, something that came up in the High Court of Delhi, there was a case where an independent director was, a lookout circular was issued against an independent director where no FIR or no criminal proceedings were there for 3 years. But there was a lookout circular that was there. Now, that kind of situation it's my belief that lookout circulars aren't meant to be applied in those kinds of situations, because the intent of the circular, frankly, is to cover situations which Rhythm rightly said, where you're a proclaimed offender, which is a very specific statutory term. There's a statutory definition, there's an act for who a proclaimed offender is. Same with a willful defaulter. There are master directions that the RBI has issued to tell you, what constitutes a willful defaulter. It means you are intentionally not paying a particular loan. You have taken public money, but you've utilized that money for some other purpose without any real intent to repay. But it doesn't intend to include an independent director working on a bank. In a bank, it doesn't. In a particular company, I apologize. It doesn't mean to include individuals who, for example, cannot pay the loan back. It's not like every defaulter is necessarily a willful defaulter, right? We had the COVID-19 pandemic. There were many companies that defaulted. So I think that's really the unfortunate situation with lookout circulars today, where the abuse is taking place. Obviously, one has to recognize that the government has an interest and an incentive to keep a track on the kinds of individuals leaving the country, and it became especially relevant in 2018, where a number of high-profile, so to speak, exits happened. The Mehul Choksi, the Nirav Modi exit. That's the background behind which these amendments happened. But you can't throw the baby out with the bathwater, and I think that's what we're seeing increasingly in litigations across the country, that whether it's in Calcutta, Delhi, Karnataka, I think that's really the issue, that because now you've got a category of people who are making decisions without, thinking the repercussions after those decisions. I think personal liberty of a lot of individuals is being affected. And I think that is, absolutely unacceptable.
Point very well taken. The matter of personal liberty is utmost important to all of us. Liberty is also one of the cornerstones of our democracy. Liberty is something that has been in so many judgments of the apex court greatly commented upon, and rightfully so. I'll go to Advocate Rhythm Agarwal. I want to ask you, you see an element of unconstitutionality in the way LOCs are being issued. Does it strike terror in the hearts of businessmen? Because it amounts to stopping them from carrying on their business activity. You are completely curbing their liberty. And let's take this to where it strikes fear. Business deals can completely go sour because you're not able to do a crucial meeting. And we all know how much important this is in business, to be able to meet, to be able to carry forward your day-to-day work. Can you explain this a little bit in practicality as the businessmen are facing it?
For sure. Actually, businessmen as a community is very much affected by it, because after COVID, actually, when accounts were turning NPAs and business were falling left, right, center, businessmen who had to travel abroad, who had no criminal cases against them, nothing doing, no investigation to join, randomly LOCs were issued against them, and they get to know about it at the airport. That is literally just arbitrary and unconstitutional in any manner. Like I said earlier as well, that it's restricting my fundamental right to trade and profession. It's restricting my fundamental right to personal liberty, my fundamental right to equality as well. For example, for one of my clients, in a very bizarre case where he had taken a loan from a bank in country X, and the bank branch of that bank opened an LOC for him in India. There is no FIR against him, no investigation he has to join, nothing doing, assuming that he did a default, assuming that he did a default in that particular country. What is the reason to stop him at the immigration at the Delhi International Airport, where he had to travel for an important business meeting to meet his investors? Rather, he's going to get capital into the country, but he stopped because an LOC is there. Right? And then a lot of times there's not enough clarity of where do you go? How do you go to the trial court? Because there's nothing. You have to knock doors of the high court, right? And
I want a very quick comment from you, Rhythm, before I go to Aditya. You have secured relief in these matters. Does the court come down heavily on these agencies issuing LOCs in some cases?
So the office memorandum of 2018, that is under challenge in front of the High Court for its unconstitutional nature. And very recently, the Delhi High Court by Justice Anu Malhotra, in a very detailed judgment of 90 pages, has upheld the order of the trial court where a CEO of a Chinese multinational company was permitted to travel, and LOC against him was withdrawn. So please imagine that if this can be done for a Chinese national, where India does not have an extradition treaty as well with China, if he's permitted to go abroad, if the courts can repose that confidence in him, then why not for people who have roots in the society, who have a family here, who have a house here, whose businesses are here? Obviously, they're supposed to come back. And if you're apprehending for them to go, you take their Google location, you tell them to join through VC and join investigation if you want them to online. In a time where everything is online, even marriage registrations were taking place online, then how is this such a big deal?
Okay. Point very well taken, Rhythm. You made a valid point that you can also join on VC. If so many things are already in court appearances happen on VC, and these are businessmen. These are not some ruffians of society or some people, who are most of them, as you said, have roots in society. Not everybody flees. Fair point. I'll go to Aditya Kumar from NKR Law Offices. Aditya, two things. Did the government have any other procedure established by law to, in a sense, address this issue, or the LOC do you think was the necessary instrument? Secondly, can you also cite cases where the court has come down heavily on misuse of this instrument called the lookout circular?
Understood. No, thanks, Tarun, and thanks, Rhythm, again for that. I think that order was very useful. I did come across it as well recently. So I think, Tarun, the first thing, there are certain statutes which anyway prescribe or give a right to restrict the movement of individuals. The most obvious example within the territory of the country is criminal statutes, right? So you have the Indian Penal Code, where if you're guilty of a particular offense, there is a procedure prescribed by law for restraining your liberty. That's not an illegal procedure because it's prescribed by law. There's a reasonable safeguards that are already prescribed by the statutes and that the courts have read into the statute. There are other statutes in addition to the Indian Penal Code that restrict movement out of the country or while you want to move out of the country. So just an example is the Customs Act. Say, for example, the customs officers are also have the power of arrest, because if they believe that a particular individual is holding a certain prohibited item, or they believe you're concealing a certain item, they have a right to hold you. They have a right to search you. They have a right to arrest you. Again, by statute. I have some sympathy though for the government in the sense that when these circulars were issued, they were not issued necessarily always with respect to a particular statute. So you have to remember the origins of the circular when it came up in 1979 was with respect to investigations in general. So if there was any particular cognizable offense under the IPC, or if you were a proclaimed offender and you were seeking to leave the country, lookout circulars were issued because you were an accused or you were a key witness, for example, but you were seeking to leave the country and therefore evade the process of law. That was the intent behind it. So that is the procedure prescribed, and you can't really say that there needs to be only certain circumstances, where this kind of circular is issued. However, what the circular itself includes is a broad range of circumstances because it includes any cognizable offense. So if if you're accused of a cognizable offense, say you, for example, defrauded a bank, one is obviously the civil remedy available to the bank, but it's also an offense that the bank can pursue through in the manner by registering an FIR. So that LOC can anyway be issued. Now, what happens is that most recently in 2018, which is, I think, the most interesting change in the circulars, because between 1979 till 2018, there were many instances where these circulars were issued. There were additional safeguards that the courts put in. So the High Court of Delhi, for example, around 2010, came out with a range of decisions that significantly modified the manner in which the government exercised or utilized these lookout circulars and led to an amendment in 2010, a significant one, where they said these are certain guidelines and protections that need to be in place. You need to have sign off by a certain category of officer. There needs to be details on why the lookout circular is necessary. These came about because of court's intervention, and there are a number of cases like that. What happened in 2018, however, was that you now said that CEOs, MDs, and chairpersons of public sector banks can now directly request for a lookout circular. That's where the crucial change happened. Because where it actually sought to cover, the circumstance that it sought to cover was a willful default, where you are, or you're an economic offender, which is above a particular monetary threshold. I believe the Act in 2008, the 2008 Act says 50 crores, if I'm not wrong, but there's a particular threshold which is prescribed. And there again, there is criminal intent. There is intent to defraud. There is intent to evade. That's the crucial part. What unfortunately happened is that the press release said people, including willful defaulters. So what ended up happening, and I'll give you a few examples, is that people who were not criminally minded, but who were just in business, who had a default, they were lookout circulars issued. Because at the end of the day, what's happening is you've got maybe a CEO isn't looking at every such request. I'm not sure, because obviously a CEO and MD, chairperson, is heading such a large public sector bank. They're not, all that they're doing is not looking at each request. There are obviously recommendations from their officers, etc., that they have to rely on. Now, what kind of situation has it led to? There was a case, for example, in Karnataka, where there was a home loan default. A home loan default where the bank had the security of the home loan with it. It was exercising its security under surfacing. It was initiating recovery proceedings. The value of the security, that is the house, was as much or more than the value of the loan taken. But by a matter of procedure, a lookout circular was issued. Now, is this the kind of situation where you need to restrict or restrain someone's fundamental right? That's the crucial part. Can we allow a mode which is essentially meant, let's be clear that restricting someone's fundamental right is a very severe step to take. It's only reserved for categories of offenses. It's not even in every offense that, you have to be arrested. So there is a certain threshold that, we have agreed as a society we need to adhere to. But now you're talking about a loan default where say, I have taken a home loan and I've defaulted for whatever reason. There may be multiple reasons I've had to default on loan. Does it mean that a lookout circular should be issued? You've got a security in place. There are civil remedies available to you, such as recovery proceedings. And if what banks should do is ensure adequate security. Ensure that they are kept abreast with in terms of what are the transactions happening on the bank, because these detailed documents, Tarun, as I'm sure you're well aware, there are very detailed lending documents that are executed. There are escrow accounts that are there in which you can monitor the transactions taking place. You can't take the shortcut and say, oh, now that they've defaulted, I'm going to issue a lookout circular, right? So that's one example. Another example happened in the Calcutta High Court, and I can give these citations. There was NCLT proceedings and liquidation proceedings against a particular company. In the NCLT proceedings itself, a forensic report was prepared. The NCLT examined that forensic report and said there is no evidence of fraud or preferential transactions, etc. But still, the bank issued a lookout circular. Now, ultimately, what happens? Even for me to get that lookout circular quashed, I have to spend months, like Rhythm very, in quite a bit of details said this is the procedure you have to adopt, you have to surrender your passport, you have to file in court. Not everyone may be able to do it. And why should my freedom, fundamental right to movement be restricted even for a second for essentially a civil remedy? So I think those are the instances which I find problematic, where this recent expansion has led to a number of issues. And Tarun, if you'll just give me an extra 2 minutes, just to talk about how we can't allow commercial civil proceedings to be brought in the domain of criminal law, or which the courts have anyway said repeatedly, or to restrict fundamental rights to ensure some civil proceeding. Just because you believe some money, you've lost some money, you can't suddenly restrict someone's fundamental right. You've got a civil remedy available to you. Go to a relevant DRT. You have arbitration clauses in these detailed lending documents. Go to court. You're essentially what you want is to get the money back. Your aim is not, because if a person is willfully defaulting, is intentionally evading, then that's a different situation. Those are covered, and those were intended to be covered anyway. But you can't cover these kinds of situations, or you can't allow these kinds of, the courts, I think, have come down heavily. And you said that how have the courts examined these situations? The courts have come down very heavily, because they have said you can't say economic interest is somebody's home loan. It's not. Economic interest is something in the Calcutta order. I'll share the citation. They go into some detail. They say that, it has to affect things like the stability of the currency. It has to affect things like the foreign exchange policy of India. There is a standard that has to be adhered to and looked at, and which is, frankly, I believe that was the intention behind the circular. But unfortunately, when you dilute the manner in which the power is exercised, what you're going to have is these situations where there is a reckless exercise of power. So that, I think, is a major problem, and I think that's what needs to be, strongly dealt with.
Point very well taken, Aditya. I'll now begin my round of closing comments because we are almost out of time. Rhythm, your closing comment on this issue for today.
So I feel that if all these agencies that issue LOCs separately against a particular person, if there is some integrated mechanism adopted, then it's going to benefit not just the person who is seeking relief, but also reduce the burden that's there on the court, right? Here, at this particular moment, all the agencies want to beat their own drum. They want to beat their own trumpet by initiating LOCs, right? But if they sing in a chorus and come together, and if one LOC is issued for one particular cause of action or one particular subject matter, one particular person, then it's just going to benefit everybody. And the dockets of the courts that are so heavy these days is just going to be, the burden is just going to get lighter, is what my suggestion would be.
Okay, point well taken. I'll go across to Aditya from NKL offices for his closing comment.
Yeah, thank you. So I take on board what Rhythm has said. I think that's a fair point, that there needs to be some coordinated action. I think secondly, there needs to be a focus on, if your aim is specifically with respect to banks, that people don't leave the country after defaulting, there needs to be stronger safeguards of bank officials saying that, okay, if you believe there has been fraud, immediately register a FIR within a certain period, because then your mechanism is in accordance with law. You've got a certain designated officer, and under the circulars, the superintendent of police, for example, or the certain CBI official who's looking at your case and saying, okay, a lookout circular should be issued in this case. So that's one safeguard I believe that should be there. The second issue I think that needs to be highlighted is that you need to increasingly place more focus on the constitutional violations by the time each order at the time each order is issued. So each time, say, a bank issues such an order and it's an unwarranted order, I believe that courts need to come down strictly even whether in the form of monetary damages or strong directions saying that, listen, you need to have these guidelines. Each bank needs to have these guidelines on when should a lookout circular be issued. It can't be issued indiscriminately. And third, just a small point is that, what is just the basic Article 14 challenges, because it's public money of India is not just with public sector banks, it's with private sector banks as well. So what's the logic with sticking to only public sector banks and CEOs having the right to issue lookout circulars and not private sector banks? So there itself, there's a fallacy, right? So there is fraud happening in private sector banks. They go to a police and then a lookout circular is issued. It should be good enough for public sector banks too.
Thanks so much for explaining this issue in detail. This is not the last show on LOC. The last word is not out on it as yet. We are expecting a judgment from the courts of law. There'll be many more opportunities to take this issue till it finally sees some conclusion which is in favor of liberty, which is in favor of business, because the wheels of commerce, when they run well, the country runs well, jobs are generated. And when that is an impediment, then the investment cycle also slows down. As they say, there is a ripple effect to every decision. And if unforeseen, then can lead to disastrous consequences. So I think the courts in their own wisdom will take a view, but till then, we'll follow it up and do more shows on it. We'll revisit this issue in another 60 days or so. I think till then, some more things would have happened on this. Some more judgments would have come. Some more observations would have come. Till then, we will wait. But I would like to thank Advocate Rhythm Agarwal and Advocate Aditya Kumar from NKR Law Offices. They made time, they joined us today. Thank you viewers for tuning in. Thank you so very much.
Thank you so much.
Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.